Yes, Mr. Lister.
Yes. Let's.
We plan to wrap up with this case today.
I'll take not more than 20-25 minutes because we have been troubling your lordship since
No, but
two.
we want to wrap up today because we don't want to allow this to spill over. It's not good from the institutional perspective, also perspective of the students. There must be finality to this day. If you are ordering a retest, students must know that they have to start preparing for retest. If you are not ordering a retest, then they know that, well, now
we are not on the tenter hooks. That's because lakhs and lakhs of students are awaiting. Before I take your lordship, what has happened, what cannot be said in the status report also. But I'll say it as guardedly as possible. Lord, when the CBI tells your lordships in a status report that according to us, this is only two places where this incident happened, Lord, it is always preceded by the interrogation. Lord, interrogation, your lordships are aware, Lord, is an effective method where initially, Lord, they are separately interrogated. They say A, B, C, D, E points individually. Then they are confronted. They say A, B, C, D, E individually. Some of the students are also, my lord, interrogated. And eventually, my lord, based upon several factors, my lord, it is the conclusion that right now the beneficiary figure would not cross 115.
155, no?
55, sorry, 155.
Yes.
Now, kindly see, my lord, the way in which, my lord, these people operate. First, as my lord Justice Pardiwala very rightly observed, they are novices. My lord, they are not, my lord, in the game. They are not big players in the game, which is, my lord, proved from the fact that at least 10 to 15 pages of the paper they could not even burn fully. Otherwise, we would not have been anywhere. Without that, my lord, unburnt or half-burnt paper, we would have been nowhere. Second, their modus operandi is very clear. Not to permit transmission to more than those who have already committed. They were taking charges. The charge is not a correct word, but the money was to be recovered in 3 tranches. First installment was paid, then second and third was by way of the post-dated checks.
Yes.
They did not transmit papers even to the solvers. The solvers were brought to the center, to the hotel, and we have, my lord, the hotel register is, my lord, recovered. They have given their identity proofs whenever, my lord, a person goes to a hotel. Everything is recovered. So their presence there on a particular day is established. They were called there. They also say that we were asked to keep our mobiles out, and they solved the papers, gave to one person who transmitted to them. So their modus operandi is, the entire thing, my lord, appears to be confined to this particular area, these two particular centers.
Yes.
And, my lord, we have been able to identify, my lord, several persons, several accused in the sense, my lord, I don't like the word accused also being used for the children, but beneficiaries. None of them are getting admission anywhere, which leads to an inevitable conclusion.
Yes. Of the 155.
We have been able to identify 35 odd. Others we are in the process.
You have able to identify how many students totally up to now?
32. They are not, my lord, they are not getting admission. The report says so, my lord.
The list of 1,08,000 or just overall in 23.5?
No, 23 point something. Most of them are not in the list of 1,08,000. Now, only thing that would happen is they would be debarred for future also, depending upon what NEET deal. But this year, that is out of question. Lord, page 120, page 22, para 52 is the chart of some candidates identified then. This is the part of the first report. Lord, none of them are falling within this. Why I'm showing this. The purpose is to satisfy our lordships that the accused and our corroborated by our findings that they got only 2 hours to mug up the questions is reflected in the result they got. Whoever, my lord, is identified, there are only 2 who have crossed 573 and 581. 570 is the 577. They've just made to manage to. Some of them have got 111. Please see, my lord, page 22. So maybe, my lord, the student was intrinsically good.
2 students cross.
Pardon, my lord.
You said 2 students cross 573.
My lord, if your lordships can come to page 22 of the first report, so that I may be, my lord, accurate. It for 3 students, my lord. This is what, my lord, as on that date we found, my lord, these beneficiaries.
Page 23.
Yes, my lord. 581, my lord, first is 581. I am not naming anyone. Then 531, 483, 300, 296, 185, 338, 573, 581. This is second, my lord, 581, who crosses 577. And that's it, my lord. There are only 2 who cross. Otherwise, 111, 431. So they got
There
2
are
hours.
three, no? There's first one is 581, then there's one 573 and one 581.
577 is required, my lords, for being in the 1,08,000.
Right, sir. So 581, we have one candidate.
And 2 with 581, my lords.
Yes.
So, my lord, my respectful submission is that unlike, my lord, the judgment which your lordships have been, my lord, assisted with yesterday, please see, my lord, the judgment. Before I come to the next point, my lord, I'll come to the judgment a little later. But I'll just point out, my lord, one more fact. The students on this side, left side, my learned friends' clients, they are also ultimately children. Most of them,
Yes.
like all of us, my lord, were misled by the fact that one telegram channel was showing that this is the question paper uploaded on 4th itself. Lordships would recall, my lord.
Yes.
Telegram, your lordships must be aware, it's like an app. It's like WhatsApp. Telegram, WhatsApp, there is some other also. Signal. It's like, my lord, Telegram is less used, but it's an app.
What about the telegram thing?
Yes, my lord. That's very interesting, my lord. And how, my lord, we can use or abuse the digital format, my lord, for creating a havoc in the country. My lord, please take report number 3. Report number 3. But I can tell, my lord, first of all, orally to your lordships. I'll not explain, my lord, how we get this, because I can, my lord, give it in a for your lordship's consumption. But one of our officers, my lord, joined this group and got this, my lord. Anyway, we'll not go into that. Kindly come to page 10 of the third report, and I'll demonstrate this, my lord. This was, your lordships have page 10.
Yes.
My lord Justice Mishra.
Yes.
Lord, this is the original version. It was uploaded, the question paper is uploaded on 6th of May, oblique 7th of May, in the night of 6th of May, my lord. They created the channel on March 6, after the exam. I'm sorry, May 6. And uploaded something on 7th.
The account itself was created on the 6th.
On 6th. Uploaded something on 7th. And they could manipulate to show
Uploading was on 7th, is it?
yes, my lords. 001 hours, my lord.
Where do you get that?
At the foot. 00.01. The last para, my lord, just above the image, comprising 12 images that included question number 1 to 76 and 121 to 129. The uploading began at 1 a.m., 0.01 a.m. and concluded at 5 a.m. on May 7th. But if your lordship sees the screenshots at page 9, please come to page 9. No, not page 9, no, page 8, 7 and 8. It would show that it is uploaded on 4th of May.
And what is uploaded is the same question, is it?
Same.
But
Uploaded on 7th.
does it have the same serial number?
Serial number, that's my lord, another, your lordship put a very interesting question.
The serial number.
My lord, the serial number should have been here. That is also masked by the person who uploaded it on 7th. The question paper serial.
What is on the previous page, that
Yes.
screenshot on the previous page,
Yes.
that says May 4, right?
They say May 4. Lord, something which is uploaded on 7th in a channel created on 6th
Yes.
can be shown as having been uploaded on 4th, and we can demonstrate that. In this very case, if your lordship permits, I have the laptop. Because the students must know that
Let us see that.
if my lord, if the DIG can, my lord,
Yes.
come and, my lord, explain to your lordships, my lord. He had explained this to me yesterday. And, my lord, your lordships can give me a piece of, not to me, I'm not, I'm technologically my lord, challenged, but otherwise, I can have a piece of paper today, upload in your lordship's presence and show it as having been uploaded 3 days later. It's that risky a technology. Go through peacefully and explain orally also. 7. On this, my lord, please come to second status report and the conclusions. Based upon your lordships have, my lord, seen the entire, all the 3 reports. I am not troubling your lordships with this, my lord, but your lordships would, my lord, with respect, my lord, agree that it is a very scientific investigation, and based upon the interrogation of the accused and other, my lord, antecedent facts, these are the 2 conclusions which will assist your lordships so far as the present purpose is concerned, my lord. At page 13, second report, conclusion number 113.7. No evidence has come on record that the solved paper was circulated in any form randomly. Except the 4 locations mentioned above, there is no evidence of any other location so far. The total number of candidates who got benefited from the stolen paper are around 155, around 30 in Patna, and around 125 in Hazaribagh. This is for the purpose of, my lord, segregation, that whether segregation is possible or not, my lord. Your lordships may also, my lord, be assisted by para 11 of the report, my lord, which is at page, I'm sorry, that may not be necessary, my lord. We have shown 2 figures, my lord. My lord, two pictures. Please, my lord, have a look at how the, right, you have shown that the position of the bag was different. No, my lord, I can show, my lord, it was not shown by my lord. Please come to page 11 of the second report. Page 11 of the second report. Well, just to show that this was done on 5th morning, apart from the CCTV footage we have, well, this is what the position of 2 trunks was in this particular institution. Image of the location of 2 trunks in the control room at OSS school at 7:53 a.m. on 5/5/24 when the front door was locked. This is image taken from the CCTV footage. Both are, my lord, connected to each other. Correct, my lords? Now, next page, my lords. Image of the 2 trunks at the control room of the OSS school at 1 p.m. on 5/5/24 when the officials went to open the 2 trunks before the examination. Both have changed their positions, my lord, and there is a tablecloth is also moved. My lord, this is to satisfy your lordships that this is the theft which happened between 8:02 to 9:23, because that is corroborated by the CCTV footage.
Yes.
Lord, just see, my lord, how your lordships have dealt with this, my lord. And I'll come to the last point. Lord, this judgment in case of Tanvi Sarwal, Lord, your lordships, my lord, latest judgment of my lord, the Chief Justice, my lord, is there, where your lordships have discussed all the judgments. But, my lord, only few of the paragraphs of this judgment, Here, the investigating agency came to a conclusion that the paper was leaked and paper traveled through several states. Lord, if your lordships can take this, 2015, volume 6 SCC, page 573. I'll not read the entire report, my lord, which was placed before the court then, when this issue was decided. Some CBSE examinations, some 2 lakh odd students. Now, your lordships may kindly see page 587. Just giving my lord a flavor of what investigative report was before the court. Just below classitum D, after my lord the italics, the above mentioned 44 beneficiaries appeared in the examination at various centers spread across the country. Out of this, 15 candidates appeared at Siliguri, district Darjeeling, West Bengal, 11 in Rohtak, Haryana, 4 appeared at Ajmer, Rajasthan, 3 appeared at Delhi, 3 appeared at Jamshedpur, etc. Then para 6. That from the investigation conducted so far, it has been revealed beyond doubt that the network of this organized gang was spread across different parts of the country. Beneficiaries so-and-so and so-and-so were already arrested so-and-so. Thereafter, again, my lord, the court says, then kindly see at page, similar, my lord, facts, my lord, where details are given, that it was an all India scam as per the report of the investigation. Here, my lord, the report, without any, my lord, reservation, say that so far we have found that these are the only beneficiaries. Of course, my lord, if some new name surfaces, his result would be subject to the outcome. But the question, my lord, which is for your lordship's consideration is that based upon a mere apprehension, which is not based upon any concrete evidence, would your lordships consider compelling or rather requiring 23 lakh odd students, painting them with the same brush as if all are guilty?
Yes.
When, my lord, the investigation has categorically reported before your lordships that we believe that this is at these 4 places. And that analysis is corroborated by the IIT report. But I don't wish to take your lordships to the IIT report, my lord. Would your lordships like to be assisted with that?
Not necessary.
Not necessary, my lord. It is also corroborated.
We have seen the IIT report.
Yes.
They've taken us.
It says the same, that the pattern is same. It's not an all India phenomena where there is any sudden spurge. And more particularly, my lord, the thing which convinces us, my lord, is that their modus operandi is very clear: to select people, go to them personally.
To
Yes.
understand one thing, is there any forensic evidence that the telegram paper was in the same form and pattern as the paper which was leaked?
It must have been,
Just ask your,
you can answer that.
any forensic comparison of the two papers were made or not?
Where the paper which was posted on Telegram on 7th or 4th, leave it right now.
Leave the date,
Huh?
just the forensic.
Leave the date. Whether it was the same question paper which was used in this examination, that's the question, my lord.
Not the same. Whether it was in the same pattern, that same font was used, same structure of the questions were there, or it was in a different format or different pattern. Questions may be the same.
I think, my lord, from the he can answer, my lord, directly, but my instructions were that while uploading it, the middle part
This question is being put for only one reason.
Yes, my lord.
If it's a leaked out paper which has been posted on the Telegram, then matter ends. If it's an information which is independent of the leaked out paper, then it's serious.
Correct, Manoj. What has happened is,
So therefore, is there any forensic comparison of the two or not?
question paper comes to the candidate in a logical.
Candidate would be getting from the same press. So the fonts and the pattern would be identical. The question numbers may vary, the answers may vary,
Yes,
but the font and structure would be the same.
it is the same.
So the question which was there in the public domain as a leaked out paper, whether it matches with the one which is there on the telegram. That is the question.
The question paper is of the question paper of this examination in the same font, I think. There is no.
Is there a report and examination of that or not?
No.
Whether any effort was done to that extent?
Any forensic report is there? Any telegraph contains the same font, this, that, and others. Is there any forensic report on that? Take it. There is none. We must take it, Manoj. But otherwise, my lord, what yesterday, my lord, we will have to rule. Absolutely. But otherwise, my lord, what I was told is that it is the same paper which was given by a student.
No, because you see, the telegram, which is the photograph of that paper is there on in your report.
Yes, my lord.
It doesn't matches with the one which is there in the case diary report. Not only in the font pattern, but also in the, as far as numbers are concerned.
Page 11. Page 11, my lord. So your lordships are comparing it with.
That booklet again, please,
Which one?
which we handed it over, the answer sheet, sorry, the question paper.
The question paper. Is it given back? For your lordship sees that. After examination was over, some student
He
gives
will be carrying the papers.
no, gives it to either uploads himself or gives it to someone, and with a view to hide his identity.
They must have masked the number. But whether the font pattern, the structure
Must be
pattern,
same. Must be.
that has to be forensically
Yeah,
examined.
yes, my lord, that should have been done, and we will do
Because the
that.
students retain the question paper after the.
They always retain, but they are supposed to give the OMR sheet back and take the paper out. Otherwise, my lord, it would be easy to trace the person, track the person. So it may not match, my lord, because of the jumbling. But it may not match because of the series being different.
Yeah, that would, so that the questions are jumbled, the order is changed.
Yes, it may not match,
It
but
cannot be done by us. It has to be forensically done.
certainly, it will be done, my lord, by today itself. It would be sent. I can make a statement. My lord, my last submission, Lord, I respectfully rely upon your lord, my lord, the Chief Justice's judgment in 2021, Volume 4, SCC 631. I'll not read.
2021.
Volume 4, SCC 631. Lord, this was also use of unfair means My lords were pleased to, my lord, consider the case law on the subject and, my lord, observe at page para 56. And I would rely upon respectfully on the last part, but I'll read that para. The decision in railway recruitment, etc., all go to emphasize that a recruiting authority is entitled to take a bona fide view based on the material before it, that the entire process stand vitiated, as a result of which a fresh selection process should be initiated. The integrity of the selection process cannot be lightly disregarded by the High Court, substituting its own subjective opinion on the sufficiency of the material which has been taken into account by the decision-making authority. Undoubtedly, fairness to candidates who participate in the process is an important consideration. There may be situations where candidates who have indulged in irregularities can be identified, and it is then possible for the authority to segregate the tainted from the untainted candidates. Now, please note this, my lords were pleased to say this. On the other hand, there may be situations where the nature of the irregularities may be manifold and the number of candidates involved is of such a magnitude that it is impossible to precisely delineate or segregate the tainted from the untainted. A considered decision of the authority based on the material before it, taken bona fide, should not lightly be interfered in the exercise of powers of judicial review unless it stands vitiated on the grounds of unreasonableness or proportionality. And, my lord, the decision-making process, my lord, I have shown to your lordships, it matches pan-India. There is no spurge. It matches earlier year and the year before that. And even the investigation suggests a localized, identifiable irregularities, my lord. And therefore, your lordships may not, my lord, exercise the judicial review. That's the respectful submission. Last, my lord, last, the question, my lord, that wrong and right question. My lord, I have also received several mails from unknown people, and I don't wish to rely upon it, but the common thing, my lord, common thread which is coming is that there are old books which are available. The old books contain a wrong answer, but in the of NCERT book.
But your instructions say that students must go by the latest edition, right?
No, my lord, the instruction says that, give me that in case of dispute, both the marks to be counted. Guidelines, my lord. Give me the guidelines, sir. Yes, lord. My lord, page 70 of my affidavit in Vanshika Yadav.
Yeah, there's one correct answer here. How can we have, and you know, the thing is, option 2 and option 4, there may be a situation where the question is ambiguous and possibly both may be correct answers, logically speaking, in a given case, that you have 4 options. Option 2 may possibly be a correct answer. Option 4 may also is really the correct answer, but option 2 is also so ambiguously framed that it may also be correct. In a given example, here, if you look at the answers, each of them excludes the other. Each of them excludes the other.
Let's see. I'm just making an attempt.
Let's just see that. IIT director ka dekho.
Lord, if your lordship sees the question, my lord, for a second, it's a trick question, my lord. I won't say, my lord, it's a ambiguous question. It's a trick question.
Yes.
Statement 1, we can, I may not read. 2, again, I may not read.
Yes.
Now, see the question. In light of the above statements, choose the most appropriate answer from the options given below. No, not the correct answer. Which is the most appropriate? There, my lord, possibility of 2 and 4 both being correct.
But see, option 2 is both statement 1 and statement 2 are correct. 4 says statement 1 is correct, but statement 2 is incorrect. So both can't coexist together.
I understand. My lord, one rules out the other.
Yes,
I'm my lord, I cannot defend, my lord, something which is not, but, my lord, kindly appreciate, my lord, the wrong answer published by NCERT book since years.
Now, just for factual clarity, the wrong answer is option 2. We are taking it as option 2, though in our order.
It may be.
We will just mention the question because you know the question number, etc., may be jumbled.
Jumbled, yes.
So I'm not sure the options are jumbled also. Options may not be jumbled, right?
The options are also jumbled.
Right, so
Options
we will
are
just,
also-
so that there is no.
Better to
factor.
quote the.
We'll just quote the question. Now tell us one thing, what, the option 2 appeared as an answer in which NCERT edition?
Yes, my lord. My lord, that appeared,
Your Lordship, prior to 2019. In 2019, the edition has been changed.
no, my lord, that appears to be not a very correct information. My lord, my information is up to 21, it continued. But subject to, my lord,
Your
my
Lordship,
lord, if some student can come, my lord, the old question, old wrong answer, till what time it continued in NCERT book? Till 22. Yes, my lord, the revised edition came in November 22. But one of the student wrote me a mail that before that we have already started preparing.
Your
Revised
Lordship,
edition came in?
what Mr. Tushar Mehta is saying, what my case is, I started preparing in 9th grade itself, from 2020 onwards. So I bought all these books in 2020 itself. I have a copy of edition in my petition. I have annexed that 2019 had the same statement, which was revised in 2019 October, and thereafter in 2023 as well. The same statement has come into being.
I think what we should do is, we should not, honestly, we should not go by the edition and all that. We will go by the correct answer. Now, suppose a student, let's take an extreme case. Let's take a case where the latest NCERT edition gives a wrong answer. But a student who has prepared well gives you a correct answer. Will we give that student?
I get, my lord, what your lordships
We
are
have to give
calling
that
from your
student
lordship.
the correct answer.
But, my lord.
IIT tells us what is the correct answer. Can
No,
there be
but-
no-
Lordship, the IITs
but
have
only a minute.
correct knowledge on the subject matter, Your Lordship.
Only a matter, only a minute,
Yes,
ma'am.
yes, ma'am.
Lord, at the
And
same
yesterday,
time.
look, yesterday we referred it to IIT with your, with your consent ultimately.
No, I consented, my lord, not.
Now, let's
But
go by the IITs. They are
the
the,
respectful submission is this, my lord, and I leave it at that, that those who relied upon an authorized text of NCERT and my lord, given the option accordingly, my lord, should also not get the, my lord, disadvantage of that.
No, Mr. Mehta, the question here is not about the correct question, rote learning. You have to have the fundamentals clear. So far as an unstable atom is concerned, it has to be a radioactive element. Then it becomes unstable. Otherwise, protons, neutrons, and
Lord, I am
electrons are
not joining
So
issue.
so being a science student, I'm a little bit aware of it.
The matter
But
ends,
the
my lord,
answer is so
ends
clear.
there.
If anybody has his fundamentals clear, he will answer it. So if he is bound only reading textbooks which are incorrect, he will render incorrect answer.
and though we gave the director time until 12, before 10 o'clock, we had it on our table
He
report.
would
because
not
they
have
must
taken more
the
than
Free
2
Express
minutes.
Must have taken probably 10 seconds to answer the question.
But my lord, the persons who will be affected would be around 4,22,000.
Your Lordship, but that also has to be considered. How many of them are within 1,08,000, Your Lordship?
No, everyone would be, they may come, they may go out. We do not know how will,
Your Lordship, the inflation itself is the big bug in this entire examination, Your Lordship, due to only this question marking. No, 290. 256 or something.
I tell you.
Was given by 9,28,379 students. So the larger proportion were all giving the correct answer. Option 2 was given by 4,20,000.
Your Lordship, the challenge was made by less than 0.6% of students who
My lord,
challenged this question.
basically, my lord, my lord, without going into which answer is correct, my lord, treating 4 to be correct. my lord, Hmm. Lord,
Which,
my lord, only one last request, only one last, my lord, my lord, question number 4 is the correct answer.
Sir, just wait till for you to wrap up for a minute. We'll not close your argument right now. Let's just hear,
Yes.
because that's the perspective of students
Students.
that others are, who lose to lose, who stand
Your
to lose
Lordship.
by marks. So let's see what,
Please.
Mr. Sulsar, don't, just keep your thought with you so
Yes,
that we'll hear you after.
if I may circulate a note. The main argument here is this applicant, she is AIR 1. She is scoring 720 out of 720. While attempting this question, she was faced with two situations. There's a tabular chart, Manoj, on the second page.
Repeat that you are,
If she
You are-
would not have attempted the
she
question,
is ranked number 1.
rank number 1, 720 out of
720 out of 720.
Yes, yes. If she would not have attempted the question, it would have been -4 for her. So she would have ended up scoring 716. If current situation is executed, now if the current choice is treated as incorrect, that will be -5 for her. So this will be 715. So now she is in a peculiar situation where she will end up getting even lesser. If she would not have attempted the question, she would have been at 715. Because the second difficulty is that in the information bulletin, there's no whisper at all of the fact that there's some new NCERT book which is to be referred. And the old NCERT book is very well on the website also. Because we have made an argument that the rules of the game cannot be changed in between. If Melods may see one judgment, 2011-10 SCC 51, because it's the rules of the game, if I may just read the relevant part.
Instruction that if there is a dispute regarding the answer, then the answer given in the NCERT will be treated as correct. Is there any instruction of that nature?
Melods, as per
So is there any such instruction?
No.
No. So the answer has to be correct on principles.
This
See,
judgment,
one more thing, very sorry. One very important thing in the FAQs which they release post declaration, what do they say? This was also done as a policy mentioned in the information book bulletin of the NEET UG 2024. That is, now see, this is very important. If more than one option is found to be correct, then 4 marks plus 4 will be awarded to only those who have marked any of the correct options. So this
Yes.
applies in a situation, Tanvi, where two answers are found to be correct.
Yes.
If two options are found to be correct, then if you adopt any one of them, you'll get plus 4. This is not a case where option 2 is correct. Only option 4 is correct.
Well, as we are saying that as per option, there are two options which are jumbled in each set. So if both statement 1 and 2 are correct, and the today's version of the answer, if we, as per this expert opinion, either or will be treated as correct if there's an ambiguity. Well, as our respectful submission is that if in case of this ambiguity, if now
I thought
plus,
you were saying that she will make it to AIMS Delhi.
yes,
Otherwise,
yes, my lord.
she will not go to AIMS Delhi, but someone,
And
you take it from us that, we are as sympathetic as anybody else because we realize that. But also there's not a situation where there's an element of ambiguity also, you see. There's not even an element of ambiguity.
My lords, may I
well,
just make a
ambiguity
principle-
is in the information bulletin. And in fact, this book is still now it's on the website. The ambiguity lies there that if there were instructions and this
That's
applicant,
still on the website, is it?
Well, even civil services examinations, the students rely on NCERT. It's considered to be standard. My Lord Justice Mishra is right.
may-
There is no instruction
argument
that
on
you can
principle.
argue, you can read only NCERT.
Right.
My lords, may-
Clear for a minute and then we'll go back to the solicitor to wrap up.
Yes, my lord, just the argument on principle. Let's assume that we don't want anyone to be disadvantaged. My lords, we want to consider what might be an overall solution over here. My lords, we're testing a competitive exam. We want to test everyone on the same basis. The version of keeping this the same, the best way would be to remove this question at all. Because then what happens is that in a competitive exam,
You didn't
Your
answer it.
Your Lordship,
absolutely undertake.
Your Lordship, the candidates who have answered it wrongly will be benefited of that negative marking, Your Lordship.
No, they
Also-
won't get the negative marking. That's the advantage. Anyone, the negative marking won't affect them then. That's the advantage. No, it's, the question is removed.
just one, yeah.
Just, Mr. Solicitor, talk to your directors here, right?
Yes,
You can ask him, we'd like your assistance on this. What if we do this? See, with the IIT report now, it's staring us in the face. Now, can we in our order, assuming we are not setting aside the whole exam, if we are setting aside the whole exam, all this is irrelevant. Then of course the whole exam goes. But assuming that they are wrong and assuming you're right on the whole exam, we will take a call on shortly. What if we say that, look, only option number 4 will be the correct option, but for anybody who answered option 2, there'll be no negative mark.
that appears to be.
What do you think? Just talk to Dr. Kamakoti and the director.
No, he is the director,
IIT.
IIT, my Lord. Your Lordship wants me to
So just have or talk to the director, NT only.
NTA.
In this regard, can I make a submission, Lords?
This one.
If.
I will hear you.
Yes.
But I am for a petitioner wherein one student has scored
Answer
720.
4 is correct. Then obviously.
720 and he has selected option 2.
Two.
You have
Will
selected.
not get
Option-
negative.
Like Tanvi,
Like, so my Lords, what I am informed that they have purchased the books in June
It's four
22.
also, but he will
Till
not get
till
negative
June
mark.
22, the same book was there, which was having the option 2 as the correct answer.
that's why what we are suggesting is that we will not give an additional negative mark.
But 4
If
marks.
we,
But I think, my Lord, it's reasonable, my Lord, with profound respect, my Lord, but Lordship may ensure that it does not become a precedent. Otherwise, for every question, there can be a litigation. And I am appearing in some of the matters, my Lord, where, no, not in this exam, their questions and answers are disputed.
Each mark.
If there is this exam is for elimination and bringing out the best student for the best profession in the country, Your Lordship.
That's what I think. There will not be harm.
Anything
Just a minute.
more? Anything more? Or you now?
No, only one, my lord. There was a not faint but attempt to allege bias IIT Director Madras. We have filed an affidavit that he has never attended any of the meeting. He is member of the general body of NTA.
IIT Madras is a member of the general body of the
General body which takes a policy call.
not coordinating the exam this year.
No, it has nothing to do. But in any case, he asked somebody else to come. We have a composition where whichever.
You said Gopal Krishnan had come. No?
Yes, we have filed an affidavit to that effect. Kindly take that on record. And what we do is, as per composition, whichever IIT has organized JEE exam last year is our member to gain their experience. So last year was IIT Madras, therefore he is.
They came into this.
Therefore he came in.
Oh,
Our affidavit, my lord, is.
You are in the
He
same.
attended only one meeting. I'm sorry, I stand corrected, in December 22. But general body meeting for overall, my lord, accounts, etc., not for conducting examination.
Yes.
My Lordship.
But I'm appearing for a petitioner. There are 56 petitioners from Gujarat. All are right students. So what I've tried to do is I've shared one written submission yesterday.
So you have all got, how many have got 720 out of that? You
721.
don't want a retest, you want a retest?
We don't want a retest.
You don't want a retest.
Most of the petitioners have been selected. They have scored more than 650. And I'm also appearing for 6 intervention applications wherein 50 applicants are there.
That's
Out of
okay.
those,
Then we have heard that now the solicitor has argued for your line of.
that's only one point. We are, because everything, the data and the facts are before my lords. The only thing is that we have tried to make a written submission where we have tried to establish the background of all those candidates.
That's all right.
10th, 12th and everything, because they
are
are
not saying.
consistent.
Fair enough.
It's not only NEET.
You can't go into individual backgrounds because you know that.
What I'm trying to say is that not only NEET they have performed well, but there is an exam of good set. Even in those exams, they have topped.
Fair enough. Yes, Mr.
My-
Vina.
Please,
Sure.
Lordship.
My Lordship, if I may.
Yes, ma'am.
On a,
Yes. Sir, I have a very limited purpose, sir. I seek to represent students belonging to tribal, rural, and basically remote areas and EWS categories from Madhya Pradesh. They are being represented by a socially minded teacher. She's a medical professor, sir. Sir, the issue here is that we face is that these students, some of them come from very remote areas, some are even Naxal regions. For them to access an exam center or even sit for a test once is a very expensive exercise, leave alone doing it again. Some of them have even qualified and they have been seeking assistance from professors and guidance during the ongoing litigation. All we request is that if a retest is ordered, these students may kindly be either exempted or some sort of exception may be made for the process to be eased for them, sir, where their prior scores may stand in case.
Ma'am, if we order a retest, we can't create an exception. Then logically we will be incorrect.
My lords,
Either we do it, we have to use the same yardstick for everybody. the fact that there may be students like your candidates coming from tribal areas, poor students will have to go through the entire process, may be a ground not to order a retest. But if you order a retest, then we can't start creating exceptions. Then there'll be our judgment will be very vulnerable. We then have to apply one cut across them.
My lords, in that case, I seek my lord's permission to assist my lords
You
with
may,
the
therefore,
judgment.
your first point that we take it as a point that, ordering a retest
Sir,
will substantially prejudice students, especially students coming from the poorer backgrounds, marginalized backgrounds,
Sir.
like your class. That point we took.
sir, with your permission, if I may put forth my lord's observation in Sachin Kumar versus DSSB, which learned solicitor sir presented. So basically, by your lordship's principle, these students are obviously not beneficiaries of any paper leaks. And if they are put on the same yardstick as the wrongdoers, then it will be a violation of Article 14. That is my lordship's observation in the matter.
Point the learned solicitor.
And such an exception has been made by the Judicature of Patna in Bihar STET leak few
Create
years
an exception only because, because then you belong to, say, tribal students. There may be Dalit students. There may be OBC students who also come from a very underprivileged background. Then where do we draw the line? There may be disabled students. Drawing a line becomes very difficult for the court, becomes a little arbitrary. So,
I would seek your
but
consideration.
We've seen your first point. We'll
My lords.
take it.
Obliged.
Thank you. What's your name, ma'am?
Tanushri Bhalla. Obliged.
With Your Honor's permission, may I just make a submission? Your Honor, I will take less than 10 seconds. I'm appearing in IA number 140274 of 2024 in the lead matter. My Lord, I adopt the submissions which have been made by other contestants. I am also appearing for an applicant who has secured 658 and he is opposing the conduct of re-NEET. He opposes scrapping of the exam. The important thing why I'm addressing the Honorable Court is, my Lord, that there have been instances where unsuccessful candidates have approached high courts, sought orders against the NT, and the high courts have judicially determined that such prayers are being made on the basis of forged and fabricated documents. And in my IA, my Lord, I have appended the order passed by the Honorable Allahabad High Court on 18th of June. When a petitioner approached the High Court, he sought scrapping and all those reliefs, stay of counseling. The NTA appeared, produced original documents of the candidate. And it was eventually then the petitioner's counsel sought to withdraw the petition. And the High Court was kind enough not to penalize the student for filing fabricated documents. So, my Lord, the only submission is that this entire exercise, bona fide students are suffering. And some...
Your point.
Thank you.
Lord,
Yes, Mr.
basic principle which has been laid down by this honorable court is, if there is a leak, Lord, in this case, leak is admitted. If after the leak,
Be excused for 10 minutes.
Yes.
Lord, after the leak has happened, and the leak was done by the gang head, Lord, who has not been arrested, Sanjeev Mukhia. What is there in public domain, the CBI has not brought it on record. This Sanjeev Mukhia, who is yet to be arrested, is involved at least in 5 major paper leak cases in UP, Haryana, Rajasthan. These are the news items. It is to be verified by them. He's not been arrested. The moment, Lord, it is established that leak has happened, dissemination is through WhatsApp mode. The handiwork of a gang operating in different states. Now, Government of India taking a firm stand that the leak is now, the beneficiaries of the leak are confined only in Hazaribagh and Patna. And this confidence emanates from only and only one fact, that the accused in custody so far have said that the leak is confined to Patna and Hazaribagh. Patna police, when records 161 statement of the accused, they talk of leak prior to the date of examination. This is also 161. Subsequent 161 statement recorded by CBI probably indicates that the leak is on that date of the examination. Now, my Lord, when the CBI officer was talking to this honorable court, his expression, as I could gather, was that so far we have not been able to recover the mobile phones through which this dissemination happened. So we cannot say with confidence that this dissemination happened only in Patna and Hazaribagh and not beyond that. So unless, my lord, because after the leak has happened, the question paper is sold and there is sufficient time, even if the leak has happened on 5th, then, my lord, this honorable court ultimately, if sustains this examination, will have to record, in my view, a satisfaction on the basis of the material before this honorable court that we are able to segregate tainted from the untainted, and this satisfaction Lord, this admittedly planning 2-3 months before by a gang. CBI officer specifically used very cautiously the word that so far we have not gone beyond Patna and Hazaribagh. Look, CBI is not so novice that they will accept the statement of the accused arrested so far and close the investigation from the angle that whether it has gone beyond Patna and Hazaribagh. It is an evolving situation. The day we came first time before this honorable court for the writ petition, because mine was the first writ petition, we didn't know anything. Besides the fact that there were news items that there is a leak in Patna. Now, the main accused has not been arrested. Now, I would say the confidence with the learned Solicitor General to say that it is confined only and only to Hazaribagh and Patna is completely baseless. Investigation is going on. Can they file an affidavit that henceforth there would be no investigation to see whether it has gone beyond? If tomorrow, today the judgment come, tomorrow this Sanjeev Mukhia is arrested along with the mobile, which would show that he had sent it for 200 people in Sikar or different stations. I got to know that from Patna people have gone to Muxar, Punjab to give a paper. And if here they say 4 locations they have been able to find. Suppose there are 100 more locations involving only, say, 1,000 people involved into 20 centers. How many people would those figures, if all of them have got, all of them will not be topping, all of them will not get 720.
So would I just assist us on one aspect? If the court cancel the examination today on the hypothesis that investigation is not complete, the main conspirator is yet to be arrested.
That's right.
And there may be a possibility, we can't say likelihood,
Correct.
but a possibility that in some future point of time, maybe even a foreseeable future, the leak may not be only confined to these 2
Correct.
cases.
That's right.
But should the court, in a situation like this where 23 lakh students have appeared, and we are dealing with the welfare of students across the country, and that's the worrisome part. We look at it this way, both ways. Let's put it 1 second. Let's put it both ways. We can't today. You are right, absolutely, that we can't say that the leak. We can't enter a judicial finding that the leak is confined only to Hazaribagh and Patna.
Correct.
For the reason that the investigation is ongoing.
That's right.
Even CBI can't tell us that. Today, as of now, it is confined to Hazaribagh and Patna. CBI's investigation in the next 15 days or 10 days might reveal a different, an evolving picture.
10 more locations.
So, we also, on the one hand, can't say that the leak is confined only to Hazaribagh and Patna. Equally, we can't today say with any degree of even prima facie authenticity or substance that the leak has gone beyond Hazaribagh and Patna in such a widespread or a systemic manner as to completely affect the sanctity of the entirety of the exam. That also we cannot say. Therefore, I asked that's why we want your assistance. Can the court, or would the court be justified in a situation like the one present to say that not on the basis of material which we have today, but on the hypothesis that some material in the future may show that the leak had gone beyond Hazaribagh and Patna. Therefore, today we cancel the exam on the basis of a hypothesis.
May I answer, my lord?
May not happen in future.
May I answer?
No.
When I answer, when I speak,
No, Matthew,
when I
please
wanted to
don't
speak,
reflect.
your lordship
We can't
prevents
hear you.
me.
You please sit down.
No, I'm among the senior, among
Okay.
the lawyers here, I am the senior most.
Sorry, you're not an amicus. I have not appointed.
No, I'm appearing for 10, 16 students.
All right.
When I wanted to
He
speak,
is-
the Honorable Chief Justice prevent me from speaking.
Mr. Matthew,
And I have an answer.
He is arguing. You will not interrupt him when he's
I'm
arguing.
not interrupting, but I have an answer to say. I
You
have
are-
an answer to
no.
give.
You don't answer my question. He is answering the question.
Okay, then, but another question. It's a
We're
general
not
question.
telling you he's on his
No,
leg.
I'm not interested in the
He is on his
engagement with
leg.
the Honorable Chief Justice, but I wanted to say,
You please sit down. I'll have to have you removed from the court. You please sit down. I'm warning you. I'll have to have you removed from
no,
the
your
court.
lordship doesn't
Mr. Udo,
respect me.
one second. One
I on
second.
my own will leave.
Mr. Matthews, I'm telling you one very simple thing. Mr. Huda is engaged in a.
Your lordship, I have tried every best not to allow me to
You have
speak and
no
put
right,
forward my
you have no
conventions.
right to intervene.
I'm not intervening, I'm leaving.
Yes.
But one
Yes,
thing is
Mr.
said,
Huda.
I wanted to say, I wasn't allowed to speak.
Yes, Mr. Huda.
When I was speaking, your lordship was showing the other side.
Yes,
And I have only one word to say, only
Yes,
one word
Mr.
leaving,
Mr.
one word to
Matthews,
say.
please call the security people, have him removed from the court, please.
I have only one to answer.
You will not say anything. You will not speak to the gallery. You will listen to me. I'm in charge of my courtroom.
Listening.
You just keep quiet now. Yes, Mr. Huda. Yes, Mr. Huda. Yes, Mr. Huda.
I'm leaving.
Yes, Mr. Huda.
Unfair.
Yes, Mr. Huda.
Please.
This is not a judicial.
Mr. Matthews, I will now be constrained to issue something which is very unpleasant. Please keep quiet. Sit down here. You want to leave? It's your choice.
I'm leaving. I'm leaving.
You don't have to. You do not have to intervene. You don't have to tell me that you are leaving. Yes.
No, because I sought permission.
See,
I sought permission to speak.
Matthews, you will not interrupt Mr. Huda. I will hear you, but I'll hear you after Mr. Huda is done. I am in charge of procedure in this court. And I've seen the judiciary for the last 24 years. I will not allow any lawyer to dictate the procedure of the court.
I
will give you a full hearing, but after Mr.
All right.
done. Yeah.
I have
Now
been,
please
I have,
keep quiet. Yes,
I have
Mr.
been
Huda.
seeing judiciary since 1979.
Yes,
Since 79.
may I, my lord,
This is contemptuous.
What you are talking about?
my response is, my lord, straight away.
I'm leaving.
Issue is no longer res integra.
Yeah.
This has been answered in para 20 in Tanvi Sarwal's case.
Yeah.
And the proposition is like this. The moment this honorable court finds that there is a paper leak and the fact has been established that it is a paper leak case. In that situation, unless and until the honorable court reaches a firm conclusion that we have been able to identify all the culprits and there is nobody left in the system who has from a back door is entering and becoming a doctor. Unless that satisfaction is recorded, no, this is my proposition for my lord's consideration. The examination cannot be sustained. And here, my lord, not only one fact.
In other words,
I'm just putting all things
in other
together,
words,
my lord, in a circle. Let me put all things together in a circle.
Your argument is that unless the court comes to the conclusion today
Correct.
that all the tainted persons are identified as of date, you have to order a retake.
Correct. That's my proposition for my lord's consideration.
On it for a moment.
Now, my lord, I put it in a sequence, especially in the effects of this case when the handiwork is of a gang operating interstate. No denying the fact. No denying the fact that the main mastermind is yet to be arrested. No denying the fact that the mobile phones used for dissemination of sold question paper have not been recovered. This, my lord, coupled with the fact which I have pointed out, but the reference, the learned Solicitor General, the analysis did, IIT NTA in their reply before this honorable court on affidavit says that CBI is investigating the matter. The conclusive opinion as to whether it was a systemic failure or not, that conclusion can be arrived at only after comprehensive analysis of everything. This is their reply of NTA in para 9 of their reply. So they are not sure themselves that whether it is a systemic failure or not. They will come to this conclusion after the CBI investigation.
Yes.
Now, my lord, in Tanvi Sarwal case, my lord, I just want to read 2-3 lines, my lord, for my lord's consideration, para 20. It says, even if one undeserving candidate, my lord, para 20, my lord, just allow me to read 2-3 lines, my lord, para 20. Even if one undeserving candidate, a beneficiary of such illegal machination, though undetected, is retained in the process, it would be a denial of the claim of more deserving candidates. At present, the examination stand denuded of sanctity. Now, my lord, as on today, I would say the whole world is watching. The paper has been leaked by a gang. Investigation is happening. Mobile phones are not recovered. Is there any sanctity left for this examination? Merely the figures are being thrown before this honorable court. Lord, only the figures are being thrown before this honorable court that if
Place figures before the court. We never throw figures.
Yes, Lord. 23 lakh people will be affected. This is way off the submission, I believe. Lord, they say that 23 lakh people will be affected. No. Lord, it is not even the first 56,000 people who get the medical colleges. Rest all want a reach again chance, my lord. When, my lord, they are comparing the figures, they are talking of 1,08,000. And everything is being, my lord, their reference sometime to 23 lakh people, sometime to 12 lakh people, sometime to 1,08,000, sometime to 56,000. Sometime they categorize from 663 marks, sometime 550. They are clicking picture wherever they get the best photograph to justify on the data that if we take from this angle, this seems 0.5%, it may be justified. Lord, a leak case where it's not even 1% of the total people who wrote the examination are involved. Not even 1% will be 23,000 people. Even if there are 1,000 people who are beneficiary of this machination, there has to be a retest. So, my lord, we are finding a imbalance in a haystack where there are few needles here and they are inserted into the system. We will not find that imbalance. Now, my lord, I conclude here on a leak that saying that the integrity has actually gone. We can't reach a conclusion that everybody has been identified and rest all are pious people and they should not be bothered any further. Now, my lord, I come to their systemic failure, my lord, which I raised in my second petition. Lord, in my first petition, I came only for leak. Lord, this is Pardiwala rightly pointed out. We came only for a leak. But, my lord, with the passage of time in this honorable court granted us time. Now, my lord, what we have found is there is absolutely no system in place for conducting this kind of an examination. Taking example of, my lord, Bahadurgarh, where now after flip-flop from yesterday, what they said, they changed 3 statements in the court itself. Now the statement is, with regard to, there were 3 centers. This I'm saying not as an individual instance. This I'm demonstrating that there were no systems in place for conducting this examination. And for this reason also, this examination has to go. If, my lord, NEET is a patient, it suffers from a multiple organ failure and the patient has to go. Now, my lord, talking of Bahadurgarh, they say there are 3 centers in Bahadurgarh. there is only one city coordinator who is authorized to collect paper. Now, for the two centers, they say the SBI paper was collected. Given to those two centers, there was some delay in distribution. So at what level they took a decision to grant extra time then and there? Who took that decision that there was not all this like superintendent in Hazaribagh colluded with these accused? All these superintendents and invigilators and the city coordinators are private people. They are charging 2,000, 2,500 from the NTA and performing their job. Now, they are the people on the spot. Are they taking the decision to extend time that in these two centers?
That you argued with.
Yes, Lord, I'm just rapidly concluding, Lord. These two centers, they extended time. Only SBI paper was given. Hardyal School, the curious case. Now, in their note, what they say is that for Hardyal School, the paper distributed amongst the student was both SBI and Canara Bank, both papers were given to the students. But this is what the 2-page note they have given today. They say at Hardyal School, Judger, initially both set of questions paper were distributed. What is this system? I fail to understand. After some time, SBI question paper was withdrawn. Now, who gave these instructions that SBI paper is to be withdrawn? If SBI paper was the actual paper, if at all, Canara Bank was wrongly distributed, Canara Bank should have been retained. But they say both were given, meaning thereby there is absolutely no sanctity. SBI is withdrawn, Canara is allowed to do. We have a video on record on which they have not commented the principal of this school, and we have the video, the transcript is on record. But let me say what she says. She says there is not a minute delay. Canara Bank paper was distributed. After 47 minutes or 50 minutes, we got to know that it should have been SBI. We contacted the agency, NTA, and they said, now its time has gone, now let them attempt Canara Bank. And we allowed them to attempt Canara Bank. This, the principal of the school is on record, and we can run the video just now. Now, in order to overcome of this, because they, after allowing the Hardyal School people to attempt Canara Bank paper all the time, they also gave them the grace marks. And they are not able to justify, because yesterday when this question was put to them,
Marks now are over because
that's right. Look, what I say, look, that's a different issue. What I say is there is absolutely no place in system. Somebody attempted Canara Bank paper, the entire 3 hours and 20 minutes, NTA grants them grace marks. Then they unilaterally withdraw the grace marks, and before this honorable court, they say, we committed a mistake, we committed a blunder, now we are withdrawing it, we are having a retest. This honorable court, the other coordinate bench, only says that, all right, you are withdrawing grace marks, you are having a re-examination. Fine, go ahead with it. But there is no adjudication that how they picked up 1,563 people, first to give grace marks and then to withdraw and a re-examination. There is another important fact, my lord, which they have not brought to my lord's notice. Out of this 1,563, 773 people were those people who could not make it even 164 marks. They were failed. After compensatory marks, they could not get even 164. They were allowed the re-examination. All students have to be put at par. And ultimately, Hardyal School participated in re-examination. Now, with regard to 3,307, they say the Canara paper was given. I want to demonstrate that for their percentage, there are no two question papers which are at par with each other. Cannot be, in my humble submission. And this Canara paper, of course, they knew that is not to be used, but wrongly used. Now, curiously, in this 2-page note, they say, out of 3,307 candidates, 7 candidates have secured more than 622 marks, which corresponds to the top 56 rank, success rate 0.05. How they have picked up entire data placed before this Honorable Court today by the Learned Solicitor General is with reference to 164 marks. For this 3,300, the reference point is 622 marks. And 622 marks out of 56,000 candidates. Probably this is the best picture they could paint here. Now, there is how these 60, what is the average of SBI paper, people securing 164 marks? And what is the average of people who attempted Canara Bank? How many on the touchstone of 164 marks? They have not given this data. So there is no parallel. Can't be. So this vitiates the integrity. Now, going, I'm just rapidly wrapping up. Going back to Rajasthan, Savai Madhopur and Ghaziabad. These students, they say late loss of time. The same day, the answer, the OMR sheets and question paper were there with these students for 6 hours, first 3 hours, 20 minutes, and later on the full time. How they can be said to be at par with the other candidates who had to attempt the same question paper? It was the SBI question paper was given to them in the morning session at both places. Ghaziabad, they refused to respond. Even Savai Madhopur, what is the justification for the same day and who took that decision? Now, they say that, all right, all these people, these invigilators and city coordinators are all private people, but we control them through CCTV camera. They are on affidavit before this Honorable Court saying that we got to know at 4:30 from social media that there was a loss of time in Savai Madhopur because a wrong medium question paper was given. Where is the CCTV camera? Why couldn't they come to know that there is a wrong question paper given to the people for 2.5 hours? And their reliance is on a social media for this. The same thing happened in Ghaziabad. So what is their system in place? Another thing, I found and pointed it out, which they have not responded back. Now, after how we have seen that certain centers are performing extremely well, especially now the comparison the Solicitor General was drawing between quota and seeker. Quota and seeker, the same amount of the total candidates were the same 27,000 at both places. But may kindly see the difference in the result between quota and seeker. It's more than 50% in every respect, on all angles. So the seeker has an advantage. Now, how it is happening, and maybe it is happening consistently. This time they are caught. The argument was that if we see the data with reference to the previous year, 2022-23, this time is no bump. I say this is happening consistently, even maybe previous years, because after 520, what is the mechanism? They have prescribed in the SOP that how soon the OMR sheet will be sealed. The question paper, the students can take out. These are the schools with no boundary wall, we have seen out of 49, only one is Kendriya Vidyalaya. There is no government school. There is no government teacher. There is no police involved there. And now after 520, the OMR sheet and the question paper is there with the invigilator and the center superintendent. Can't they have a teacher, biology teacher, physics teacher there in the center and say, now we will deposit it in the city center somewhere and we can deposit it by 8:30, and in the meantime, all right, if not more, let them attempt 10 more questions. And all of them are not for MBBS, because the merit goes, the people who get admission, the merit goes even up to more than 10 lakh in the BAMS and dental colleges, etc. BDS. Last time, I'm told it went up to about 12 lakh. So we are looking for the spots where the people are getting 100% or 700 or 650. No, this is also a breach. If somebody is able to attempt 10 or 20 more questions, So the system, I would say there is no system in place. And it is too easy to manipulate. And with this kind of a system which the NTA has adopted, their own roll, their employees are about 22, about 33 are on deputation. And rest is all they keep on issuing checks from here. Some videographer in seeker is hired, check is given, and now how good the job is performed, there is nothing to monitor. No, my lord, an examination with this kind of a checks and balances, I would say it's completely farce and can't be upheld. And my lord, just one thing to add. Now, it is a coincidence, my lord, I read to this honorable court the news item which showed the e-rickshaw. Straight away, the news item was CBI, my lord, CBI is here, they will confirm that this e-rickshaw carrying the question paper, my lord, because question paper, there's a test booklet which contains.
Report number 3 gives that photo, clarifying that it's not a question paper, it is the OMR sheet.
My lord, if I can clarify, just
there are 129, the same photograph saying that this.
Just hold on, I'm just wrapping up in 2 minutes.
Yeah, no,
Lord, what the submission is now, you see, I didn't
in my status report.
My submission is, Lord, there is a report, and let the CBI respond to it with no filters in between. OMR sheet and question paper is in the same envelope, my lord, has it. It is never ever separate. And the report specific is that instead of this courier, private courier company, instead of taking the question paper on 3rd of May directly to the SBI and Canara Bank, it took it to straight away to this Oasis school where the breach take place on 3rd of May. Now, what is the investigation on that angle? Lord, if I can invite your kind attention to the news item, this is Times of India. Lord, page 12 of my first supplementary note, I have placed the Times of India report. If I can, Lord, just read a few lines from here. The sources told TOI that CBI attention turned to Oasis School located in Mandai Road, Kali Chowk, and its staff. The agency began gathering digital evidence and discovered that e-rickshaw had gone directly to Oasis School on May 3rd instead of proceeding to the SBI main branch where it was supposed to be stored. This is a report quoted by Times of India from the source of CBI. Now, what they say, except saying that it is because the report is somewhere below the e-rickshaw, Indian Express says it is OMR. OMR, my lord, will not go into trunks. Lord, let me explain this. After, as per their case, after examination at 5:20, the OMRs are to be collected. They have prescribed a specific cloth under which those are to be sealed, and those are to be given to the city center. There is one center in the city where all this is to be deposited. Hazaribagh, what was the center at Hazaribagh where these OMR sheets were to be finally deposited? And how come this, again, it is being, e-rickshaw is taking these OMR sheets? In a center, if there are, I do not know how many students are there in this Oasis school, but even if there are 200, 300 people, these are 300 pages. Those 300 pages will not go into the trunks and e-rickshaw. There is something which do not meet the eyes of this honorable court. Everything is not placed before this court. So, they have not come clean with regard to Ghaziabad. They have, yesterday, saw it with regard to Bahadurgarh. They first said Hardyal school, they attempted full-time Canara Bank paper. They said that for the other centers, we gave the grace marks. Then today they say, no, the other centers, we didn't give the grace marks because there was a loss of time. We gave them the extra time. Now, my lord, who decided there was a loss of time in, maybe in Ghaziabad, loss of time in Rajasthan, Savai Madhopur, there they did not give extra time to attempt the same question paper. They asked the student to rewrite between 6 to 9. And in Bahadurgarh, some superintendent, all these private people, they took a decision that, all right, we extend it for 1 hour or half an hour. Lord, may kindly send for the files as to who was competent to take this decision, who actually took those decisions. Are the principals of the school taking these decisions? How they picked up and chose 1,563 people? Who took those decisions? What are the file notings? What are the communications? Their only object as of now seems to be that anyhow we persuade this honorable court to sustain the examination, come whatever may. The entire confidence that the leak is limited is born from the fact that accused are saying that it is not beyond Patna. Why would the accused will confess that we have 100 other post-dated checks which are lying somewhere else and we had supplied question paper somewhere else also? At least CBI did not sound that confident that there is nothing beyond Patna. The expression used was so far. So, my lord, I would at the end conclude by saying this: there is absolutely no sanctity left. There is no SOP, there is no system fix that how soon the OMR sheet is to be sealed. My lord, I'm sorry to repeat it. And there is no system. Lord, may kindly notice this. There is no time frame given for sealing of OMR sheet in their SOP, which I have placed on record. They did not think it appropriate to find that if somebody living in Gujarat is applying for Maharashtra and giving address of Maharashtra, why wouldn't they ask the candidate to submit a proof? Lord, we go for a ration card, they ask for a proof. For an Aadhaar card, Lord, Aadhaar card is almost everyone. Lord, I'm sure all these 22 lakh candidates had the Aadhaar card with them. Why they're permitting this kind of malaise in the system? So grateful. Much obliged.
One,
Please, please.
just 2 minutes of time. Buddha is substantially.
Yes.
Just one
So,
bullet points.
Your Lordship's question that today, given the situation that the investigation is incomplete, the investigators have told Your Lordships that it is possible that about 155 students alone were involved, only 155. It is not fair to upset nearly 24 lakh students. That is the question that Your Lordships had. Would it be in those circumstances fair to upset the entire exam? Firstly, my lords, what Your Lordships should examine is what has come out in this hearing so far. Has it reassured Your Lordships that a fair exam was indeed held? That when there was unfairness which was reported, was it fairly investigated? And what the investigating agency has told Your Lordship, that it took place at a very brief point of time on the day of the exam, and therefore the contamination was very limited. Is that something which Your Lordship would place reliance on? I'm going by exactly what the CBI said. The CBI says that there is an organized mafia in these matters. They work on a business proposition. 3 months prior itself, they have sent out their agents saying, if you are willing to pay, we will get you the paper. And we will see to it that you get a rank of your choice. Now, what the CBI has told you is that the leak has occurred between 8:02 and 9:26 on the morning of the 5th. When one Mr. Pankaj Kumar goes into that room in Hazaribagh, extracts the paper, takes photographs, reseals it in that envelope, closes the trunk, comes out, and only thereafter physically goes to another place in Hazaribagh, gives it to the solvers, or from outside after, so that takes it to around, from 9:26, it takes it to 9:30. Your lordships will mark the timeline from 9:30 to 12:30. That is the timeline that the CBI has told your lordships. At 9:30, if the papers are, photographs are either taken physically or WhatsApped, then the solvers are split, and let's give them another half an hour to answer 30 questions, 20 questions each that they get. That takes it to 10. Between 10 and 12, because 12:30 they're dropped off back. Students are supposed to have read the papers and wrote, memorized it, and then gone. Now, my lords, for that uncertain chance of 2 hours, which parent will pay 30 lakhs to 75 lakhs in advance? Please take just that. That is why it is implausible. Is there anything yet to bring up? Please, my lords. Now, my lords, I do not have the benefit of any of the reports, but I am going by by the first FIR which the Patna police registered. And I submit to your lordships that where it is clear that on the night of the 4th, the students had solved papers and were asked to memorize. And despite all that, they still failed. So obviously, when preparations are made for people to pass exams or to get a good rank, they need adequate time. This kind of timeline does not work. This brief 2-hour intervention, my lords, is not plausible. And in fact, the OSS school from where it was, where this leak happened, there is a video of the principal saying that when the earlier EOU asked, showed him how this had happened, their conclusion seemed to be that the leakage happened before the papers went into the bank. There is a video of the man when he was not under arrest. The leakage has probably happened on the 3rd. It happens in Hazaribagh. It is caught in Patna. And it is at the behest of Sanjeev Mukhia, who has not only a history of conducting leaks, he is now a big investor in leaks. Yeah. My lords, yes, that he's argued.
Anything else that you have to add?
Please, my lords. The question is, what is the precedent that 3 of your lordships will hold? Most of the judgments that your lordships have delivered are 2-judge judgments. And if your lordships were to be called upon to say that, look, this much of a leak or of a localized leak is not something which we will interfere in, and which we will possibly say, for want of a better term, wink at, then as a lawyer, I might tell your lordships that for the next 20, 30 years, we will be forever striving to say, no, this is not a leak of that kind, this is a leak of this kind, and it is such a small one. So there, my lords, just before I end, my lords, this precedent point came up much earlier, where the argument was made as the solicitors made. And I beseech you, rest once the law to your authority to do a great right, do a little wrong. And Portia's answer was, it must not be. There's no power in Venice can alter a decree established. It will be recorded for a precedent. And many an error by the same example will rush into the state. It must not be.
Yes, thank you, Mr.
I'm
Yes,
grateful.
my lord. I wanted to answer one question of Justice Pardivada and Justice Lordship's question. And when the questions are raised, any member of the bar who was actively participating in the discussion can certainly answer it. And I did not do anything wrong. And I'm sorry, I was unfairly treated. That's a different story. Now, that's a different story. Let me come into the case.
Make your submission.
No, coming to the state. Yeah, my lord. Now, I'm amazed by the kind of discussions which has been going on here. We have been conducting a criminal trial. We are going to the niceties. We have called the CBI. But solicit what kind of discussions which have been going on. The issue is, you ask a common man, a man in the street, there is an examination leak. I came, my petition, I said only one thing. There has been a leak. A leak has been happened, then there is no alternative. There is no alternative than a retest. It certainly leaves inconvenience. Certainly. And only thing that can be thought of is how to reduce inconvenience. And I made a suggestion, which my friend also adopted, that this test be conducted as a NEET preliminary examination. 13 lakh students are qualified, and they be taken for the final examination. And this is an administrative issue. Today, because of PAS, etc., we treat many things which are in the realm of falling in the exclusive realm of governance into the court. And my lord, therefore, this is something the government did a great injustice to the court. The government it was their problem. It was a issue of governance, and the government very conveniently did not raise the maintainability of these petitions. Allowed questions, the detailed arguments to be made for days and days, and they're literally shunning away from their responsibility. There is a government. This is an issue concerning lakhs of people. It is a call of the minister. It is a call of the government, and the government has failed to. I'm not anti-BJP man. In fact, I supported BJP. I advocated for voting for BJP. But what happened today? This is something utterly, I'm not using a very strong expression, unacceptable. The government of the day is accountable to the people. When your lordship, I always say, when your lordship takes a decision, my lord, that only binds the parties before you. When a parliament takes a decision, we are all present in the parliament, and we are symbolically present in the parliament. It binds all of us. In the last couple of years, the governance, what the parliament ought to do, what the government ought to do, the courts are forced to do. Courts are forced to do. Therefore, my lord, the question today is, what is the given situation, what is to be done? Admittedly, there is a leak, and this leaves no option than to cancel the examination, as rightly Justice Vikamnath has said, 0.00% doubt, examination has to be cancelled, and that is the only option. This is a matter which should have been concluded in 20 minutes, and good that we spent a good lot of time. I'm no quarrel about it, and therefore, my advice to the court is that court should not enter into the domain of the executive. Let the government do its job. Let the government answer to the people. The parliament is going on. Session is going on. The very NEET issue is before the parliament. And here is a Solicitor General. He doesn't even oppose. I'm for the petitioner. I'm strongly advocating the cancellation of this examination. Still, I said, as a matter of principle, a lawyer has to speak about the fundamental constitutional principle. A fundamental constitutional principle is that these are our administrative issues. And if, assuming that the government, at least the matter should have been relegated to the government should have directed to take a decision. And the government, supposing that the government has taken a decision after hearing both of us, parties affected, not only those who are asking for cancellation of the examination, but also those who are asking for non-cancellation of the examination, because they are the one who stand to benefit by the results. Both parties, to the extent possible, unlike a court, the government is under no obligation to hear everybody. Because the government represents the people, and therefore no obligation to hear everybody. But court, when a court decides a matter, it is under a duty to, my lords, listen to everybody. Otherwise, my lord, that resinter alios acta, altori, nosori, non-debet. Court has no jurisdiction to bind anybody who is not before it. So having this fundamental principle being stated, and whenever every PAL comes before this court should certainly adjust to itself. The people affected are not here, and we don't represent the people of this country. And these issues concerning the public at large cannot be decided behind the back of them. These proceedings are not representative proceedings. These are proceedings, in my case, 16 students were affected by it. Therefore, my lord, when this case came, the only option is to throw the ball back to the government's court, and the government to take a call on the question of cancellation, and the government would have done it in moments' time. It wouldn't have been able to justify this examination, not even one moment. The government would have come with the conclusion, the decision to cancel it forthwith. And the government conveniently, very conveniently, saying that is a non-adjudicatory, the Solicitor General says, non-adjudicatory litigation. What is that? Non-adjudicatory. There is nothing like non-adjudicatory. Court's job is to decide disputes. Court's duty is to decide disputed questions of fact. and apply the law. If the issues are non-adjudicatory, there is nothing. It is administrative. And my lord, I conclude by saying one word. My lord, I forgive your lordship for all the insult to me and my lord, humiliation. I forgive your lordship, Lord, forgive them for they not know what they are doing. I have nothing in my mind. I have the greatest of regard for your lordships and lordship Padiwala also. I have the greatest of regard, though I was insulted. I don't keep anything in my mind. But my lord, this NEET examination has to be cancelled forthwith. It cannot be delayed 1 minute because precious time of the students are lost, and a fresh examination has to be conducted forthwith. And it is for the government to decide whether it has to be for the 13 lakh students who was selected, or it has to be for a lesser number. And these are areas where the court should step in, because what is governing the matters of administration, but those in governance alone come to know about it. Somebody said certainly NEET is a very loosely conducted, all outsourced. But that is true. But in a governance, outsourcing is necessary, without which no government can function. Everything, the NEET department cannot do it. So most of the things which my friend Hoda and Sanjay Khadge argued, with respect, I disagree with that. And only my submission is, this is an issue which will be thrown to the government's court. Let them decide. Let them decide. Let the parliament is gone. Let them answer to the parliament. And let them not shirk their responsibility and throw all public issues to the court's domain. Because I say so, because average time which an ordinary litigant who comes for grievances is 93 seconds. When I come to your lordships for a SLP, it is dismissed in 93 seconds. And I had a recent incident where my SLP was dismissed even 60 seconds. So therefore, we have to revisit it. The PA business has to be discouraged. And only petitions, here at least affected parties are there. My petition is not PAL. My petition is somebody who is seeking declaration of their fundamental rights. And my lord, I conclude, the research has to be cancelled, examination has to be contested. Greatly obliged.
Please, just 2 minutes.
Your lordships.
Lords, your lordships asked a question to senior lords, that in this situation, what your lordships should be doing in case whether the investigation is yet not complete. Because this has been answered in that judgment which I referred yesterday. I just want to repeat a paragraph so that will assist your lordships. Before that, that Tanvi Sarwal was not cited before your lordships in the Sachin Kumar's judgment. I tried to check it. That's also a 2-judge bench judgment. This is also 2-judge bench judgment. So this was not cited before your lordships. That's what I could.
No, but the subsequent judgment which I decided was a case where the government had decided to cancel the entire exam.
So here,
so there was no question of the court being required to cancel exam. So the legality of the decision of the government to cancel the entire exam wasn't called into question.
Please,
that was
here we are not able to segregate the tainted from the the good people. Just lordships, you may see paragraph 18. If lordship wants, I can. Para 18 2015 6 SCC 573. The same situation before your lordships, as in today, third line, though as on date 44 such candidates have been identified, having regard to the modus operandi put in place, the number of cell phones and other devices used, it is not unlikely that the many more candidates have availed such undue advantage. So many more.
Para 15 is relevant. Para 15. 1-5.
Let's read para 15 and then.
Yes. The investigating agency in its report has stated in clear terms that from the disclosure recorded, it is beyond doubt that the strategy of providing answer key has been executed by an organized gang with a network spreading over different parts of the country. The Inspector General of Police, who was present in this with his team, having been granted the leave, submitted that the investigation is full swing and in progress, etc., etc. It was their case that it's pan-India.
So, here today the situation is they themselves are saying, that we are yet to investigate further. Now that is also looked into in paragraph 18 if your lordship sees.
Right, let's see.
Yes, though as on date 44 such candidates have been identified. Having
so then last line he says, frankly, admitted that in process it might not be possible to identify. But it's an all India issue.
Para 18 now.
Yes, para 18, third line, though as on date 44 such candidates have been identified, having regard to the modus operandi put in place, the number of cell phones and other devices used, it is not unlikely that many more candidates have availed such undue advantage being a part of the overall design. and in the process have been unduly benefited qua the other students who had made sincere and genuine endeavors to solve the answer papers on the basis of their devoted preparation and hard labor. In view of the widespread network that has operated, as in this case it appears so, as the status report disclosed, and the admission of person arrested, including some beneficiary candidates, we are of the opinion that in view of the strong possibility of the identification of other candidates as well involved in such malpractices, that examination has become a suspect. As it is, the system of examination pursued over the decades has been accepted by all who are rational, responsible, and sensible to be an accredited one for comparative evaluation of the merit and worth of candidates vying for high academic pursuits. It is thus necessary for all the role players in the process to secure and sustain the confidence of the public in general and students fraternity in particular in the system by its unquestionable trustworthiness. Such a system is endorsed because of the credibility informed with guarantee of fairness, transparency, authenticity, and sanctity. There cannot be any compromise with this imperative at any cost.
Also,
So, even at the cost of 44 students and a possibility of more people being found, so your lordships did set aside. The learned solicitor general said 2 lakhs. My information is there were 6 lakh students. This is the same API, All India pre-medical test, the same which was to happen before NEET started. And it is to be conducted by CBSE in that. Yes, Milords. Para 19, segregation only of already 44 identified candidates stated to be the beneficiaries of the unprincipled maneuver by withholding their results for the time being, in our comprehension, cannot be the solution to the problem that confronts all of us. Not only thereby, if the process is allowed to advance, it would be pushed to the vortex of a litigation pertaining thereto in the foreseeable future. The prospects of candidates would not only remain uncertain and tentative, they would also remain plagued with the prolonged anguish and anxiety if involved in the ordeal of court cases. Acting on this option would, in our estimate, amount to driving knowingly the students who are not at fault to an uncertain future with their academic career in jeopardy on many counts. Further, there would also be lurking possibility of unidentified beneficiaries of the candidates stealing a march over them on the basis of the advantages availed by them through the underhand dealings as revealed. Having regard to the fact that the course involved with time would yield the future generations of the doctors of the country who would be in charge of the public health, their inherent merit to quality for taking the course can by no means be compromised. So, even if 10 to 20,000 students come up in the front and I am pushed outside the 1,08,000 Milords, ultimately my chances.
Anybody else?
Only one more
Your
thing.
Lordship,
One more thing. Your Lordships yesterday had indicated the issue which I said was the OMR sheet issue. Your Lordship said it's a personal issue, an individual client. The OMR issue, sorry. In the OMR issue, in fact, it appears to be a part of the systematic failure because it's not only my client, because she has not given she has not been given the OMR sheet. When the OMR sheet, when she got initially, she calculated it came to 650, around 650. But when the result came, it is 103. They have been emailing to the NTA, give the OMR sheet. They have not given till now, Milords. So, Milords, and others also.
Lordship, my one submission is a very important thing to say. Lordships, then my solicitors and CBI entire focused only here the Hazaribagh and Patna. Lordship, it is the not focused here the 5 layers scams. Point number 1. Lordships, there is the before of the examinations. Point number 1. It means there is 9 February 16 months before. Second is Lordships, when notifications came, it means there is the forms filling forms. It means 9 February to 16 March, in which regions a lot of candidates appeared in the different centers. Next is third layer, is the Lordships. The examination dated, it means the conducting jobs 5 May. The 5 May in which regions a lot of candidates, some are the belong from the Odisha to appear in the some other places. In which regions, Lordships, it is the SBI and Canara banks and other types of the issues. It is the not given in the submit is the reports. Third is the Lordship, after examinations, there are a lot of issues in which regions the 720 marks, which is got by this out of the 720s, 718, 719, 600 and above. And Lordships and others issue the 4 and 6 layers. The Lordship, my humble submissions, please Lordships, on the behalf of the petitioners, Lordship, please reconduct the exams.
My lord,
Lords, may I-
Lord, in item submissions for the applicants in IA number 137554 of 2004. That's, we stand for some of the candidates who have secured high marks. But one submission I would like to make, so far as a leak or theft elsewhere than the 2 or 3 identified places are concerned, I would submit that a decision may not be based on suspicion or conjunctures, because these are all matters to be proved beyond reasonable doubt. I would like to suggest one decision, Lords, AR 1994 Supreme Court 626. AR 1994 Supreme Court 626, where at paragraph 44, the Lordships referred to the Privy Council decision. Of course, it concerned fraud alleged in a civil proceeding. Now, it is held at paragraph 44, my lords. Mary, in so and so, AR 1941, Privy Council 93.
What is the name of the case?
Lords, it is, Svenska Handelsbanken Appellant versus Indian Charge Crop and others.
Sudan bank guarantee.
Not bank guarantee. So that's right.
Fraud or bank guarantee.
I only submitted that it concerns allegation of fraud in a civil proceeding.
Fraud and that was the reason. You got your point. Thank you.
Proof.
Your Lordship.
One more submission, Lord. One more submission, Lord. So far as the question, the particular question is concerned, eligibility for NEET test is the board examination. The board examination prescribed the NCRT books. And many of the students were following the NCRT books, which provided both the answers. Therefore, both the answers given by the students are based on the NCRT books, which is the basis for the basic examination for the NEET test. Therefore, they may not be, that question may not be deleted, and therefore the students who gave the correct answer may be given the marks that are due to them. That's all my submission.
Lordship, I am
Lordships,
appearing
in
successful petitioners in IA number 140031.
You don't want a re-examination.
I don't want, Lordships, my humble submission.
People have argued that now.
One-
How many
Lordships.
people will just because you're for an intervener?
I understand, Lordships. One specific point, my lords. In Tanvi Salwal case, the Lordships interfered and cancelled the examination within 45 days. Whereas when it comes to we people, after the result was declared, there was a Rawlsian ignorance, wheel of ignorance, my lords, when it came to the candidates who were involved in Tanvi Salwar case. Whereas in our case, my lords, after we being declared successful, on the basis of a conclusive police report, Lordships interfered in Tanvi Salwar case. Whereas in this case, my lords, police report, CBI report is not as conclusive as what happened in that case, my lords. So we being successful, brought into the rigor of re-examination again, might be, my lords, it may be difficult for us. So on behalf of the successful candidates, I plead. Lordships.
Your Lordships, I am appearing in item 21.34. If your Lordships allow for re-NEET, we are covered. But if your Lordships do not allow for re-NEET, your Lordships, our relief is restricted to seeking parity with 1563 students. Your Lordships, we are the tribal students from Meghalaya who appeared from 2 centers, Riboi and Jowai. So, your Lordships, admittedly, there has been loss of time as apparent from the representations made by the center coordinators and also admitted by the NTA.
He's getting it.
Your Lordships, that has been also admitted by NTA in their response dated 17th of July.
Extra time for that. That's your individual grievance in regard to the Meghalaya student.
Please, your Lordships, and
What to do on that.
please, your Lordship.
Your Lordship, in case there is no re-NEET, I would pray that if the answer, option number 4 is considered to be only correct answer, I would expect only if the
My lord, I'm in item number 24. It is on a completely different tangent. Since 2020, before the Delhi High Court, we have been agitating that the NTA officials are involved in the swapping of my OMR sheets. My lord, in the digital.
All right, we'll deal with your case.
My lords, I am also here with the same grievance. When the NTA answer sheet was released, I scored almost 509 marks. I had attempted 131 questions. And when the final result came out, I scored -6, which was very shocking for me.
Interestingly, the Delhi High Court had confiscated the OMR.
All good things.
Also, my lord,
At the blood, since this is the end of the hearing.
Mr. Solicitor, now, have you constituted a committee or something like that?
We have.
Now, what?
Yes.
Give us some idea about that.
We have. I'm sorry, my lord. I should have pointed that out, my lord. There is a 7-member committee, my lord. It's subject to your lordship's approval. It is.
He's not doing it.
Yeah, yes. But it is
With ministers and
R21 of the counter affidavit, page number.
R21 of the counter.
Yes, madam. It is headed by Dr. K. Radhakrishnan, former chairman ISRO and chairman Board of Governance, IIT Kanpur. And Dr. Randeep Guleria, former director AIMS Delhi. Professor B.J. Rao, Vice Chancellor, Central University of Hyderabad. Professor Ramamurthy K., Professor Emeritus, Department of Civil Engineering, IIT Madras. Shri Pankaj Bansal, co-founder, People Strong and board member of Karma Yogi Bharat. Professor Aditya Mittal, Dean, Student Affairs, IIT Delhi. Shri Govind Jaiswal, Joint Secretary, Ministry of Education, as a member secretary. Lord, it is placed at R21 with my counter, my lord, counter dated.
July.
4th July.
Return after 5 minutes.
Please. Lord, on the, since at the end of the day, on a lighter note, sometimes your lordships must be missing the virtual hearings where there is a facility of muting us.
We'll be back in 5 minutes. Dr. Sikri has something, Mr. Paul?
Lord can go away if not you.
So after we come back after 5 minutes, all right. Then listen.
Yes.
Just come back after 5 minutes. Just take a comfort break and